Distribution of property after person's death without will in India. Intestate succession in case of death of a male. In case a male dies intestate, i.e. without making a will, his assets shall be distributed according to the Hindu Succession Act and the property is transferred to the legal heirs of the deceased. The legal heirs are further classified into two classes, Class 1 and Class 2. Class 1 heirs consist of the immediate family linked by the male. It includes wife, son, daughter and mother. All the people in this class shall equally divide the share among themselves. The Class 2 heirs consist of many relatives who have been classified into categories and placed in a hierarchy. Preference is given to the one ranking above, wherein if there is even one member available in the higher, preceding, category, then all of the property shall pass to the members in that category and none to the ones coming after that, succeeding. However, if there is no one available in the higher, preceding, category, then it shall pass to the members following next in the category, succeeding. Referring to the chart given above, you will see that in case of a married male, the father is ranked above the category of grandchildren, brother and sister. Here all the three of them shall share the property equally, i.e. 1/3 each. If by chance neither Class 1 nor Class 2 heirs are available, then it shall first pass on to the agnates and then cognates. Succession in case of death of a female. After the amendment of the Act in 2005, females have been given equal rights of inheritance as that of a male. However, the distribution of her property is different from a male. A lady is the absolute owner of her property whether self-acquired or inherited. Any property whether movable or immovable earned or inherited by her will be considered, either before, during or after the marriage, even before the commencement of the act, as her stridhana. A lady who dies intestate, i.e. without leaving a will, her assets will be distributed according the Hindu Succession Act. According to the Act, the first right on her assets will be of her husband, son and daughter, including the grandchildren, but only in case the children are not alive. If she is unmarried, then the right devolves upon her parents. In the absence of above people. In the absence of the above-mentioned people, unlike the male succession rules, where the heirs were divided into two classes of heirs. Here there are no classes, although there is a hierarchy that defines the order in which the assets shall be distributed. The one ranking first in the order will be preferred over the one coming later in the rank. And only in the absence of the higher rank shall it pass to the next in order. However, there is a difference in distribution of the property with respect to the manner in which the property is acquired. The property can be acquired in three ways: self-acquired, inherited from parents and inherited from husband or father-in-law. There is a slight difference in the distribution of the three. Self-acquired. In the first case, where the property is self-acquired, if the girl is married and the children and husband are also not alive, in that case, the property shall be distributed according to the chart where the first right is of that of the heirs of the husband and so on. But if she is unmarried, in that case also, we follow the above chart and skip the one applicable for a married woman, i.e. husband. Therefore, for an unmarried girl, it is the parents, both mother and father, who will share the assets equally. And in the absence of the parents, the one next in order, i.e. the heirs of the father, will be entitled to her property and so on. Inherited from the parents. Now coming to next, inheritance from parents. Here, even if the girl is married, in the absence of children and husband, the right of the property will not vest in the heirs of the husband. Property acquired by way of inheritance from the parents will only be passed to the heirs of the father and so on. Same goes if the girl is unmarried. Because by default there are no children and husband. Inherited from the father-in-law. Just like inheritance from parents, in case of inheritance from father-in-law or husband, which is applicable only in case of a married lady, the property shall be passed only to the heirs of the husband, in case the husband and children are not available. It will not be passed to the parents of the girl even if they belong to the hierarchy.
Don't forget to like and subscribe this channel for more informative videos.